Welcome to Justice, a lawyer's hangout, where we dissect legal issues and educate the public on the law. I am Chizaram Lillian Oyike, and here with me today is Professor Ifolu John Koni, a professor of law at the Redeemers University. Welcome and thank you for being here, sir.
Thank you very much. Thank you for having me.
Thank you very much, sir, for being here. On today's episode, we will be discussing arrest and bail. Every day, people are arrested, sometimes lawfully and sometimes not. Many don't know their rights or what steps to take. That is why today we are shedding more light on the two key questions. When can someone be arrested and when can they secure bail? Now, Mr. John, let's begin with the basics. What does arrest mean under the Nigerian law, and what are the conditions that can be met for lawful and unlawful, and what are the lawful rights of a person who has been arrested, sir?
Thank you very much. To start with, the power of arrest is vested in the Nigerian police
Yes, sir.
under Section 4 of the Administration of Justice Act
Yes,
and Section 33 of the Police Act.
yes, sir.
So these are laws, instruments that empower the police to arrest anybody suspected to have committed a crime.
It's fine. Yes, sir.
Uh, so, so law, statute legally,
Yes, sir.
the police or members of the police force have the power to effect arrest
Okay.
under the law. Now, what is an arrest? An arrest is taking and keeping a person into custody, okay, pending his trial.
Yes, sir.
That is an arrest. There must be a confinement, there must be a touching, and then the person must be. So you don't just arrest somebody by words from and say, "Hey, you are under arrest." No,
You're under arrest.
there must be yes, there must be a taking or keeping of that person into custody by a lawful authority. But that is exactly the way the Black's Law Dictionary define it.
Okay,
And that
that.
is the way it is also yes, that is the way it is also captured under the Police Act and then the Administration of Criminal Justice Act. So the police have power to effect arrest. Then it must be done lawfully. Lawfully.
So, sir, what are the lawful ways that the police can effect arrest, sir?
Yes, there are two ways of looking at it.
Yes, sir.
Whether it should be an arrest with warrant, where the law stipulates that an arrest must be done with warrant,
Okay.
that there must be a warrant of arrest. Once it is not there, any arrest effected without warrant will amount to an unlawful arrest.
Yes, sir.
That is one. But there are circumstances also in which a police officer can arrest a suspected offender without warrant.
Wow. Okay.
And these circumstances are provided for under Section 18(1) of the Administration of Criminal Justice Act
Yes, sir.
2015.
Yes, sir.
Uh, and also even under section 63 also of the Police Act. Now, especially if you look at that section 18 of the ACJ Act, the circumstances are there. And this relate to situations where very serious offenses are suspected to have been committed, or where where a person commits an offense in the presence of a policeman. Any arrest where there is need, where there is no provision that there must be a warrant. Once the offense alleged to have been committed can be situated within the provisions, within the circumstances listed under Section 18 of the ACJR,
Yes, sir.
then that means that arrest is unlawful. So those are the two ways of determining whether an arrest is lawful or unlawful.
Okay, so
If it
now
was done, without warrant, where the law provides that there must be a warrant, or if the offense alleged to have been committed cannot be situated within all those things listed, all the items listed under Section 18 of the ACJ Act.
Okay, sir. Thank you very much, sir, for answering that question. So, also, sir, how long can someone be detained without being charged under the Nigerian law? And also, what legal safeguard exists against prolonged detention, sir? Because I know that a lot of the police can arrest people and keep them in detention without actually charging them to court, sir. So, we want you to throw more light on this particular issue, sir.
You see, under our criminal jurisprudence and even constitutional jurisprudence, when every person suspected to have committed an offense is presumed to be innocent until the contrary is proved. That is what is contained in Section 36 sub 5 of the 1999 Constitution. So, and then besides that, under Section 35 sub 1 and 2 of the same Constitution, every person is entitled to right to personal liberty. There are circumstances under which this right can be denied. Now, a combined reading of these two provisions, Section 36, sub 5 of the 1999 Constitution, and then Section 35, subs 1, 2, and 3 of the same Constitution, shows that when a person is alleged to have committed a crime, is entitled to be admitted to bail if he cannot be charged to court immediately. So in order to preserve his right to personal liberty, because he is still presumed innocent, the law makes provision for admittance to bail. So, and if you look at Section 35, also sub 5, sub 4 and 5 of the Constitution, it has stipulated the maximum period within which a person can be detained without trial. And the maximum period is 48 hours. Now, the law provides that where there is a court within 40 kilometers radius, that person alleged to have committed a crime must be charged to court within 24 hours. That is where there is a court of competent jurisdiction within 40 kilometers radius from the scene of the alleged offense. Now, where there is no court within 40 kilometers radius, the law provides that the police can detain for 48 hours or for such longer period as the court will permit. Now, meaning that generally, as a matter of law, a suspect cannot be detained for more than 48 hours without an order of court extending the period of detention. So any detention that is beyond that, without a lawful order of court, will amount to illegal detention.
So, but sir, there are situations where, let's say, practically, in reality, right now in Nigeria, police would arrest people, they would detain them for more than 24 or to 48 hours. Now, in that situation, what redress can this person or the arrested person take, sir?
Of course, the person arrested is entitled to seek legal redress. That would be a breach of his fundamental rights. Yeah, that's Section 35, sub 4 and 5 that talk about that stipulate the maximum period within which a suspect can be detained. Is a fundamental right. Is contained in Chapter 4 of the Constitution, which embodies all the rights described as fundamental human rights. So whoever becomes a victim of an arrest or detention, stretching beyond 48 hours, without a lawful order of court, is entitled to seek redress in the court of law by way of the enforcement of his fundamental human rights. And he can claim damages. There are many cases authorities on that. They can claim damages for unlawful arrest and detention. And the
Okay.
court will hear him out.
Okay. Thank you. Thank you very much, sir. Let's take a short break
Thank you.
and we will be right back.
As the people and members of LJE Green Community, we share a deeper commitment to protect not only our environment, but also the rights and dignity of all individuals within our reach. Every day we are faced with the responsibility to uphold human dignity. If you see something wrong happening around you, do not turn a blind eye. We must act because that is where our role as ambassadors come in. Being an ambassador does not require any superpower. It requires awareness, compassion, and the willingness to speak up. If you see something, say something. It's our duty to stand up for justice and amplify the voices of those who can't speak for themselves. One voice can spark a movement, and together we can create a nation that values human life. You can reach us on 070-5236-8821 or visit our website at www.ljenigeria.org to report a violation. Remember, if you see something, say something.
Welcome back from the break. Thank you very much, sir, for being here. So, sir, I'm going to ask you one more question, and I'd appreciate if you answer briefly, sir. Thank you very much. So, sir, the question I'm going to ask you is based on is going to be on bail. I mean, you've covered that up already, but sir, despite that, like they say, the principle of bail, that bail is free. So why do people still pay for bail in practice, and what factors contribute to this reality, sir?
It's simply a problem of ignorance. And that is why the civil society needs to do a lot of enlightenment on this issue. I know that a good number of members of the civil society are also are legal practitioners, and every lawyer knows that bail is free. It is right to bail is not only is it free, but it is constitutional.
Yes.
It is constitutional. That's why all the instruments embodying criminal justice make provision for it, for right to bail. In the ACJ Act, you see section 63 of the ACJ Act, the Constitution, section 35, 4 and 5 of the Constitution, as like I have stated, section 36, all of these instruments, even the criminal code, the penal code, all instruments embodying criminal law and justice make provision for bail. And you won't find it in any law in Nigeria, where it, or even anywhere in the world, to the best of my knowledge. Even if you go under the cover of international criminal law and justice, you won't find it anywhere where it is stated that you have to pay any dime, any amount of money to secure bail. It is free. Bail is free. It can be on bond. You know, there could be need for surety and all that, but it doesn't mean that somebody must pay before you are admitted to bail. Yes. So it's a question of ignorance on the part of the citizens.
Okay. Thank you very much, sir, for your thoughtful contributions. We have come to the end of this segment, and to our viewers, remember, being informed is your first line of defense. Stay aware, stay empowered, and don't be afraid to ask questions. Join us next time on Justice, a Lawyer's Hangout, and follow us on all social media handles as LJE Nigeria. Until then, bye.